Do individual state laws regulating social media violate the Constitution? That was the question considered in oral argument today at the Supreme Court.
Now, legal experts on both sides of the debate say the cases are essential in monitoring government censorship of online speech. Washington correspondent Hilary Powell is following the cases at the Supreme Court and joins us now with a breakdown of the justices' comments on the laws at the center. Hilary?
Well, as one counsel put it, social media is the new town square. The question remains, how do you protect everyone's right to free speech and expression in that space? The justices who heard arguments today seem to be concerned about whether government-affiliated social media users are acting in their official capacity when they're using social media that they also conduct business on.
Citizens, you and I, we can block anyone we want from our social media accounts because we're not government officials. So the line is really between if you're acting as a private citizen or are you acting as a public official.
Tuesday's cases, O'Connor-Ratliff versus Garnier and Linke versus Freed, involve whether social media falls under First Amendment protection for California school board officials and a Michigan city manager who blocked social media users for comments they saw as harassment. In the California case, the Ninth Circuit Court of Appeals ruled 2 California school board members violated the First Amendment by blocking 2 parents who criticized them on their personal Facebook and Twitter accounts. Lawyers for the parents argue the justices should side with the lower court.
Receiving feedback from constituents is an important part of their duties as trustees. The content and appearance of the page confirms that the district court's finding that these pages were, quote, used as a tool of governance. Because the trustees were doing their job when they maintained and then blocked Dr. and Mrs. Garnier from these pages.
Justice Ketanji Brown Jackson wants to clarify duties of public officials.
I mean, can we believe that, say, the mayor's duties include receiving feedback from the public if there was a duty to get feedback from the public?
Lawyers for the school board members suggest a social media page can't automatically be assumed to be part of a public official's duties.
She suggested that the page was somehow their duty. One of my clients closed the page, just shut it down. No one thinks he was acting in breach of his office. He was in dereliction of duty.
Whatever the outcomes, the justice's decision may have implications for which users are deemed too toxic for Twitter or Facebook. These are the first of a total of 5 cases that the Supreme Court will hear this term regarding social media as it relates to government. John, Jenna.
Yeah, Hilary, of course, social media is so personal, or it can be. How will the justices determine what makes a page official office business?
Well, justices are especially concerned with the Facebook and Twitter pages of officials because these officials in these cases had private pictures, too, of their family. So they're looking at whether they created these pages before they became public officials. They're also considering whether a reasonable person would have considered these government pages, even if they did not include a disclaimer that they were using it for private use. So all remains to be seen, and we should hear an outcome for these cases sometime next year.
All right. At the Supreme Court, Hilary, thank you so much.